to WMG webinar 14 or 15 or whatever we're at now. Glad to see everybody here. Certainly, I think this is probably one of the most technical webinars, because the province has done a lot of changing with respect to the emergency, with respect to how the legislation works. The Municipal Emergency Act, as an example, has been repealed. So we've got a lot to tell you today. So our agenda for today, Tim is going to give us a legislative update. He's going to talk about the emergency orders, the declaration of emergency, Bill 197, and ongoing gathering restrictions. Then I'm going to talk about the new regime with respect to electronic meetings, and also the new ability to do proxy voting. And then Jen is going to talk to us about the duty to accommodate family status and the return to school. That's something that all employers are going to have to be careful of. Nuala is going to talk about the masking program and some of the outcomes and hostility that's come out of masking. And then Mia is going to talk about both her reminders for the municipality, continuing digital transformation. And she's also going to talk about some of the contact tracing rules that have been put in place now by the province, which has sort of strengthened that process. So because we have a lot to cover, I'm going to jump right in and get Tim to go ahead with his legislative update. This is certainly something that you'll want to pay attention to and be clear on, because the ground again has shifted. So over to you, Tim.
Thanks, Paul, and thanks again, everyone, for joining us this morning. It's nice to see a number of familiar faces from past weeks, so that's really great. This week, as Paul said, there's been some fairly large changes with respect to the legislation. The biggest change being the Reopening Ontario Act has passed as of July 24th. What happened with respect to that act is, although it essentially, the declared emergency for the province has ended as of July 24th. However, the orders that were still in effect when the declared emergency ended have transitioned over to this new act, the Reopening Ontario Act. And so essentially, that means that the orders that have transitioned over, and those orders include things like the rules for stage 3 reopenings, the rules for areas in stage 2, the order with respect to patios, which you may recall exempts temporary uses of land for a restaurant patio from certain sections of the Planning Act, that has transitioned over. And so those orders that transitioned over to be under the Reopening Ontario Act, and I should mention, if you're looking for them under the Emergency Management and Civil Protection Act, which is the act that they used to be under, you actually won't find them there if you go to the ontario.ca site. So you'll have to Google the Reopening Ontario Act and click the regulations, because what essentially they've done, that the province has moved all of those over so that they're under that act. So essentially what that means is that all of those orders that were set to expire on July 29th were continued for 1 month as of the date, I should say 30 days from the date that the Reopening Ontario Act passed. So as of the 24th, those have been extended for 30 days. There's a process in place for the Lieutenant Governor and Council to further extend those orders, even without a declared emergency, and actually to make other orders as well in the absence of a declared emergency. Essentially, it's given the province quite a significant power to make orders even in the absence of a declared emergency. And so we'll have to see what the province does with that. I know a number of civil liberties groups have taken issue with that and said essentially, you know, it's an example of the province perhaps taking on too much power, using this pandemic as a you know, perhaps as an excuse to consolidate power. Whether that's true or not, they certainly do have significant expanded powers to make orders, even though there's no declared state of emergency in the province anymore. As I say, some of the orders that expired, would include things like the closure of outdoor recreational amenities. That would be the one that required parks, etc., to be closed. That one has expired. We have. I'm just thinking of some of the other ones that expired. There, most of the ones that will affect the day-to-day operations of municipalities and people going out, for example, I know we've talked internally about going out to restaurants and patios, and Mia is going to talk about something that just came up with respect to contact tracing, which I don't know if any of you have been to restaurants lately. I haven't, but I understand that under this new that restaurants are supposed to take certain information from people to ensure that if there is somebody who has COVID-19, that if they're able to alert people, or the province is able to alert people. So Mia will talk a little bit more about that. Some of the other major events that have happened include the passage of Bill 197, which we alluded to. Well, we talked a little bit about it last week, I think. But some of the major things that Bill 197 does, and I won't go into detail about this aspect because Paul's going to talk to you about electronic meetings and proxy voting and all of the good things that came about with respect to those aspects of meetings. But what it also did, there's some changes, significant changes to a number of different acts. One of the major ones is the Environmental Assessment Act. The province has essentially taken certain public projects out of the EA process. It's also streamlined certain infrastructure projects for a smoother EA. So there's going to be some major changes that we're going to see to the environmental assessment process. That's a major change that happened with Bill 197, in addition to the changes to the Municipal Act that Paul will talk about. Another major change that came up was yesterday, I believe it was yesterday, the province announced that schools will be reopening for September. That's a bit of a surprise to me, maybe not to others, but essentially what I understand from the announcement is that schools are going to open for September. Elementary schools are going to open for conventional learning. There's going to be some high schools that are designated by the province that are going to have essentially a blended online and in-person curriculum. And then there's mandatory mask wearing for students in grades 4 through 12. In the younger grades, it's going to be encouraged but not required. And so schools are going to be reopening. It's going to be interesting to see how that works in practice. But that's a major development. A number of the colleges and universities, I think all of the colleges and universities have moved to an online delivery for the fall. So the province reopening the elementary and secondary schools certainly to me comes as a bit of a surprise. But that's what the province is doing. They've also announced that they're going to invest significant money in building new schools. So 500 million is going to be allocated to new construction of schools. So the idea there being to limit class sizes to permit social distancing. So some major developments there as well. if there's questions, I'll look at the chat. I don't have too much more to say. The one thing we were talking about just actually before everyone jumped on is, and to the extent that people are interested, I can send out an email blast perhaps after the webinar. Is it looks like the public gathering regulation has expired as of July 17th. So it looks like that wasn't carried over. We're just going to verify that, but I think it's important to maybe do a blast out about that once we do, just so everybody's aware. That was the regulation that restricted public gatherings to 10 people. Well, first started off with 5, then went to 10, and then to 50. And so it would appear that regulation was expired, but we're gonna get that information, and we'll hopefully be able to send that out to the group. Otherwise, the key takeaway, I think, is that with the Reopening Ontario Act, orders are still in place. Stage 3, stage 2. Effectively, very little has changed with respect to the orders, except the major change being now they're transitioned over to this new act. They're extended for 30 days. The Lieutenant Governor can extend them again, even in the absence of the declared emergency, and the provincial government has the power to make orders that it essentially as it sees fit, even in the absence of declaring a state of emergency. So orders are still in place, no declared emergency. One of the programs that will affect is, we talked in another webinar about infectious disease emergency leave. That continues, but declared emergency leave, which was a separate leave of absence, is over. That was a leave of absence that applied to people who had orders that directly affected them, versus the infectious disease emergency leave, which continues so long as COVID-19 continues to be designated under the Act. That was the leave of absence that applied, for example, when you have to stay home for example, for childcare needs, if there's not childcare available, or if you're supporting a loved one, spouse, or certain other family members, for example. So that infectious disease emergency leave continues. That declared emergency leave, which was a very narrow leave of absence, is over with the termination of the declared emergency. But let's say key takeaway: most of the orders continue. Stage 3 orders, stage 2 orders. As what that also practically means is that the orders that require mandatory masks in those jurisdictions where a health unit has, like Algoma District, for example, where a health unit has issued an order with respect to mandatory masks, the authority for those orders continues. So mandatory masks where a health unit has passed that continue. And we'll see how the province makes use of this, their expanded powers as we go forward. As I say, Bill 197 has some very significant changes that Paul's going to talk to you about with respect to electronic meetings and proxy voting as well. It's going to have a significant impact as we go forward. With that, as I say, I know we have a packed agenda. I'll look at the chat. If there are questions that come up, happy to answer any. Big changes though. We'll see how things pan out, and I'll turn things back over to Paul, and I'll watch the chat, and hopefully, if there are questions, I'll be able to answer them for you.
Thanks a lot, Tim. So I'm going to just start by picking up on something that Tim mentioned. He was talking about the gathering limits that previously had been subject to a regulation under the Emergency Management and Civil Protection Act. So now those appear in regulations that are made under the Reopening Ontario Act. And so there are specific regulations both for areas in stage 2, which we have some still in the province, and stage 3. And the stage 3 rules contain the requirements with respect to gathering. So we're allowed in our area in stage 3 to have a gathering of up to 50 people if the gathering is indoors, and up to 100 people if the gathering is outdoors. And to be clear, if the gathering is both indoor and outdoor, the indoor rule applies. So just to pick up on what Tim was saying, that requirement is still in place, although it's under different legislation. And that essentially is what I want to talk about with respect to electronic meetings. Because at the beginning of the COVID emergency, the province enacted specific legislation with respect to municipalities so that we could have electronic meetings. And it's important to understand, although Tim is saying that most of the emergency orders have continued, it was not an emergency order that allowed municipalities to have electronic meetings. It was actually the Municipal Emergency Act of 2020. That act has now been repealed as of July 21st. And so the ability for us to have electronic meetings under that piece of legislation disappeared. Additionally, during the emergency, the province amended the Municipal Act to allow us to have electronic meetings under Section 238 of the Act. But those amendments also have been repealed. And so if you were having electronic meetings under the emergency provisions of the Municipal Emergency Act or the Municipal Act, those the authority for that is now gone. And that really takes effect on two dates. One is July 21st, and the hard date is July 24th. So if you now want to continue to have electronic meetings, and I think almost every municipality I've spoken to does, Bill 197 does allow municipalities to amend their procedural bylaw to permit electronic meetings. And the nice thing about this is that the restrictions about a declared emergency are gone. So now council can decide to have electronic meetings without restriction. In other words, it's not only during times of emergency, but it's any time that council wants to have an electronic meeting. And so Bill 197 is a great big piece of legislation that amends 20 different acts, but it specifically in Schedule 12 amends the Municipal Act so that council can amend the procedural bylaw to allow councillors to attend electronically, and for the people attending electronically, when I mean the councillors attending electronically, to be counted in quorum and also to participate in closed sessions. So it's important to look at your procedural bylaw amendment, because with the emergency gone, the amendments that we did under the Municipal Emergency Act aren't of effect anymore, because those amendments allowed you to have the electronic meetings only during the emergency. The emergency's gone, so that needs to get fixed. So we have prepared a new bylaw to allow municipalities to continue to have electronic meetings and to continue to have councillors participate electronically. And I see a question about whether they can be counted as quorum, and yes, they can absolutely be counted as quorum. So the bylaw that we've put together allows any or all of council to participate electronically, specifically allows the head of council to chair the meeting electronically, permits the clerk to clerk the meeting electronically. And then we flip over to the next issue, and that is the attendance of the public. Even though I know some municipalities are starting to have in-person council meetings, many of our municipal clients don't have the facilities to allow the public in an unrestricted manner to attend council meetings and still maintain social distancing. I should say, the Reopening Ontario Act and the rules under the stage 3 still require us to prevent more than 50 people getting together in an indoor facility. And even if you can have 50 people in there, you still have to have facilities such that they can stay 2 meters away from each other. And so those social distancing issues are still in effect. So the bylaw that we have prepared continues the process of having council meetings that are open to the public electronically. And any of you who were on the early webinars will remember that we developed a theory that where the Act requires us to have a meeting at a place that is open to the public, we said that the internet and using things like Zoom or Skype or even conference calls is a place that's open to the public. So our bylaw continues to allow meetings to take place in the absence of the physical public, but permitting the council meeting to take place where the public are allowed to attend electronically. Now, something you've also heard me say is that many municipalities have seen public engagement and attendance at council meetings electronically increase. And so we wanted to ensure that municipalities could continue to use this tool. And you could do any sort of hybrid of this as well. So depending on the size of your council chambers, you could say, the first 5 people could attend in the public gallery because we can space them out, and the rest can attend electronically. So this, the bylaw we've prepared allows the flexibility and compliance with Bill 197. Now, what I would say is that some municipalities declared their own emergencies, and those emergencies may continue to stay in force right now. And if you're one of those municipalities that declared an emergency under Section 4 of the Emergency Management and Civil Protection Act, then the old amendment still remains in effect. You can still rely on the old amendment because you have your own declared emergency, and that was the trigger to permit the electronic meetings. So if you have an emergency, you're in less of a rush to amend your procedural bylaw. But if you don't have a municipal emergency, it's critical that you do amend your procedural bylaw if you're going to continue electronic meetings where councillors are participating in quorum and participating in closed session, and if you're going to have electronic meetings where the public are not permitted into council chambers. So I think that wraps up the public meeting issue. Great question from Debbie Tonelli. Does council have to meet physically in order to adopt the bylaw to allow them to meet electronically? No, they don't have to do that. And in fact, just like under the Municipal Emergency Act, the legislature has seen fit to allow council to have a meeting to adopt the amendment to their procedural bylaw electronically. And so it's very important procedurally that that be the very first thing that council do at any meeting that they had after July 21st, or definitely after July 24th. Now, the reality is some municipalities have had meetings without amending their procedural bylaw, and after July 24th, when the technical authority for those meetings disappeared. That's not great, but what I would suggest that any municipalities that find themselves in that situation do is at the very next meeting that you have, and even call a special or perhaps even an emergency meeting to do this. First thing you do is you amend your procedural bylaw. The second thing you do is pass a confirmatory bylaw confirming all of the decisions that happened at the meetings between July 24th and when you amend your procedural bylaw. That's not a complete silver bullet. And so council may want, if you've got important issues, if you've issued contracts, if you've given people authority to enter contracts for the municipality, you may want to revisit those and redo that at a properly constituted meeting, because it would be open to a ratepayer to challenge any decision that you made in those technically illegal meetings in the Superior Court if they were so inclined. So if there's an issue that you dealt with in this period between the emergency meeting electronically and the new Bill 197 meetings, I would either go back to it or at least pass a confirmatory bylaw. So I think that answers the questions that I've had so far. And again, I'll be happy to answer them as we go. Next issue is proxy voting. So the province has decided to permit councils to amend their procedural bylaw to allow proxy voting. Now, I won't read you the rules, but I will tell you that there are restrictions on proxy voting. And first of all, the way that it works is one councillor can give to another councillor a proxy to vote on a particular question that you've got on your agenda. Now, any one councillor can only have one proxy. So you cannot have a situation where councillors have a quorum of council altogether by proxy. And that avoids our problems with the ombudsman and open meetings. So you're only allowed one proxy. The proxy voter is, so the person that holds the proxy is only allowed to count for one person for quorum. So the person that's absent and voting by proxy does not count as quorum. There are provisions with respect to recorded voting. And then there are a lot of provisions with respect to the conflict of interest that could arise. And so the Act actually indicates that if a proxy voter has a conflict, let me rephrase that. If a councillor has a conflict, they cannot give their vote by proxy to another councillor to vote in an effort to get around the conflict under the Municipal Conflict of Interest Act. And the same applies with the person receiving the proxy, pardon me. If they have a conflict, they can't vote the proxy vote on an issue that they have a conflict. There are then rules where, as has happened sometimes, if you discover a conflict after the meeting, you have to declare it. If you discover a conflict and you've given the proxy in advance of the meeting, you have to let the clerk know to revoke the proxy so that that vote doesn't happen. And then we have a great question from Michael. Is the proxy still considered absent for the 3 absent vacant seat provision? So that's with respect to the eligibility for council. If you miss 3 months of council meetings without authority of council, your seat becomes vacant. Michael, the answer to that is it's going to be up to council to put that in their bylaw with respect to proxies. It's not dealt with in the Act. And so you would need to deal with the issue of absence and whether somebody can simply remain away from council and vote by proxy for 3 months and not have their seat declared vacant or not. That's going to be for council to decide. So happy to answer any questions on that. And now I'm going to pass the floor over to Jen, who's going to tell us about the tricky issue of accommodating family status with respect to childcare and particularly the new return to school and voluntary nature of that. So Jen, over to you, please.
Thanks, Paul. Hi, everybody. Thank you so much for joining us on this Friday before a long weekend. So like Paul mentioned, I'm going to talk to you about the duty to accommodate family status. So we know the Ontario Human Rights Code prohibits discrimination in employment. This means municipalities as employers have a duty to accommodate any needs that employees have that are related to protected grounds. We most often see this come up with disabilities. Employees bring in a medical note and we have to accommodate their medical restrictions dealing with their job duties. But during COVID, this has come up a lot with family status issues. So family members dealing with the medical needs of others, or dealing with your caregiver responsibilities, particularly since schools and daycares have been closed. These issues have already come up, and they're going to continue to come up, especially as the schools are opening up and people are maybe opting out of returning their children to school. First, what is family status? So the Human Rights Code defines family status as, it's pretty limited, I'll read it to you, the status of being in a parent and child relationship. That seems pretty narrow, but the Human Rights Commission and decision makers that have been hearing family status cases have expanded it to sort of recognize the ever-changing modern family, any type of parent-child relationship, like foster parents, adoptive parents, step parents, that sort of thing. The definition does have its limits. So we're not talking about anybody we would consider our family members, like grandparents, aunts, uncles, nieces, nephews. Those type of caregiving responsibilities might fall under the regime for the infectious disease leave that Tim mentioned earlier. The duty to accommodate family status is a separate regime from that leave. So under the ESA, if an employee has caregiving responsibilities related to family members under that broader definition, they're entitled to an unpaid leave of absence. That's what you get under the ESA. And if an employee tells you that they are triggering that type of leave and you determine that they're eligible for that leave, the duty to accommodate is separate from that. So if family status is triggered, you want to consider whether the employee is requesting something based on what would be a legitimate need, and whether there's a link between that legitimate need for family status and a workplace rule. So for example, if you have a parent that's your employee and they usually rely on their grandparents for childcare, maybe their grandparents are vulnerable, they don't want to see family members, or they just want to be more distanced during COVID, so that normal childcare is no longer available to the employee. The employee finds some other form of childcare, but it takes them a little extra time in the morning to transport their child. So they ask you as the employer if they can start later every day. Family status would be triggered, so you have a parent-child relationship. I would venture to say that is a legitimate need, transporting your child to childcare so you're able to report to work. And that need is linked to the workplace rule of starting at whatever it is, 9 a.m. every day. Compare that situation to maybe you have an employee who's taking care of their vulnerable parents. They're doing the grocery shopping and dropping it off at their parents' house. They want to leave early 1 day a week so they can go to the grocery store and avoid those lines that start accumulating at 5 p.m. So they ask you if they can leave early once a week. Yes, family status would apply because you do have that parent-child relationship, even though your employee is the child there. But is leaving work early to avoid a line a legitimate need? No, that's more of a preference. So your duty to accommodate, I don't think would be triggered there. So be aware that just because family status might apply, the employee does have to have a legitimate need for your duty to be triggered. So consider why the employee is making that request when you're figuring out how to respond. If the duty to accommodate is triggered, you have to provide a reasonable accommodation. The employee has a corresponding duty to facilitate a reasonable accommodation. They can't just demand their ideal or perfect accommodation to meet their need. So in September, if the schools are opening up and an employee decides they're going to opt out, they're concerned about safety with their child, and they say to you as the employer, I want to work from home, I need to be able to work from home so I can watch my child during the day. Do you have to automatically grant that accommodation? No, you have to grant a reasonable accommodation that meets legitimate needs. Maybe you consider working from home a reasonable accommodation. The employee can function highly while they're at home. It's the type of work that you can do from home. That's great. Go ahead and grant that accommodation. But if it's not reasonable to you because it doesn't meet some legitimate needs, canvass other things that might be considered reasonable from your point of view as the employer. Maybe it's helping to find other childcare, letting the employee work staggered hours so they can alternate childcare duties with another parent, or putting them on some sort of leave of absence. Some degree of hardship is expected when you're granting these accommodations. There is going to be some time, inconvenience, financial cost, but there is the ultimate limit of undue hardship. Just as we know when we're accommodating disabilities, that threshold to undue hardship still applies to accommodating family status. One more thing to be aware of when you are granting accommodations is making sure you're following the proper process so your accommodation isn't affecting the fundamental terms of employment. So maybe since March, you've had an employee that's been allowed to come in late every day because they're dealing with childcare obligations. Once schools open up and they send their child back to school and they don't have those childcare needs anymore, can you as the employer reassert their strict start time? The answer is likely yes, but it's going to depend on what process you followed and making sure at all times the employee knew this was a temporary accommodation to deal with their childcare needs related to the pandemic. So I hope I've flagged for you some issues that you will likely face, the general process that you should follow. Of course, if you have any questions or something comes up and you want us to guide you through the process, please contact our office. We're happy to help. And I believe that's all I have to say for you, so I can pass it over to Paul.
Thanks a lot, Jen. Certainly, accommodation is an issue that we have been dealing with a lot in our practice during the COVID crisis. It is a gray and thorny issue, and so if you're in a situation where any of Jennifer's flags have come up for you, please give us a call. We can give you some guidance about how to deal with the situation to protect yourselves and, of course, to protect your workers. On a similar note, one of the things that we're seeing and encouraging is a system of self-reporting with respect to COVID exposure. We are seeing a lot of employers adopt systems like that, and if you're thinking about doing that, we think it's a great idea, and we would be happy to help out. So I'm now going to pass this over to Nuala, who has clearly contravened the rules and is down in sunny San Francisco. And I guess we're going to hear why she's down there and why the heck she's not wearing a mask. Over to you.
Hi, good morning, everybody. Yeah, I'm in sunny San Francisco, and it's a free love sort of a place, so masks are not required. Wishart just has endless fun, so they sent me down here to see, what was going on. But I am absolutely delighted to see everybody again. Really gives us a sense of comfort knowing that you can join us. Lets us know that you're safe and healthy, and it really means a lot to this firm. Thank you again for joining us this morning. Absolutely beautiful Friday before a long weekend. I know how precious your time is, so I hope we are able to give you some valuable information during these sessions. I want to take a few minutes and speak about enforcement of the mask orders. And what we're seeing is, as you've noticed, everywhere you're going now into enclosed public places, masks are required, and city halls are going to be no different. They're going to be required where there are public convening and indoors. The trouble is, when people are not wearing their masks, who's enforcing that? You're seeing it more in the States, particularly with big retailers like Walmart and Trader Joe's, where they have frontline staff enforcing the mask orders. So that means you have somebody who's making in the United States about $9 or $10 an hour, requiring people to wear a mask or not enter a retail establishment. And the largest retail union has just taken that on, saying it is an unfair obligation to put on retail staff to have them enforcing the mask orders. And when you first hear that, I think as polite, obedient Canadians, we probably think that wouldn't be much of an issue here. But what we're seeing is, on the heels of being cooped up, being isolated, and we talked last time or some time ago about compliance fatigue, that people are just sick of complying with the orders. This is another aspect of it. Civil libertarians largely are coming forward and saying, Big Brother can't muzzle me. I'm not going to wear a mask. People are saying, and we can talk about it on another session about, oh, I've got a disability, therefore I cannot wear the mask. It really impacts my breathing or whatever. But also the civil libertarian aspect of it, that it is my right, that I don't have to be masked. And these arguments are getting very heated and in some cases violent. So the takeaway for today's session is, from my piece, when you have staff returning, you've got public coming to your establishments, do not have your frontline staff responsible for the enforcement of the mask requirement. You can have signage that says no mask, no entry. You can tell frontline staff you're to ask people to wear a mask. And if the people say, no, we're not going to wear a mask, that needs to be escalated to somebody beyond your frontline staff. The same hierarchy that you have in place for disruptive or possibly violent visitors to your site, that needs to trigger with the masks, and you need to advise your frontline staff. They're not responsible for enforcing it. You can ask. If people do not comply, take it up to a higher level. I was reading actually a really perturbing case about a lady in the United States, and it reminded me a lot of many of the clients that are on the phone and on our Zoom meeting today. It's a very small little town in the United States, a town of 900. And she works at a retail store making $10 an hour, and she's in her 60s. And she said plainly, I would not be working here if I didn't need the money. I'd rather be gardening. I'd rather be with my grandchildren, but I need the money, so I work. And she described some of the incidents that came across her day when people were not masking. She said they actually had a sign outside her little shop that says no mask, no entry. People still come in without masks on. And she said one man came in and she said she had her mask and she signaled, maybe you need a face covering, and he lifted his t-shirt up and put it over his mouth. So she said, now I get to see his bare stomach. That level of brattiness is what I call it, is taking place. She had a different name for it, and my eldest daughter, when she was little, whenever we'd go to the gas station, she'd say, "Mom, are you putting gas in the gas hole?" So I did always put gas in the gas hole. And this lady in this article that I was reading about said, we've heard of COVIDiots, and now there's mask holes. And I thought, yeah, exactly. So just be sure that your frontline staff is armed, knowing that there's a very good chance that people are going to fight back against the mask orders. And one final piece, just I ask you to consider, I expect that messaging is going to come on masks soon. We've already, I saw a young lady wearing a Fendi mask. So designers are getting in on it. I'm sure political messaging is going to be part of it. Bans are going to be part of it. So if your dress code says there's no political messaging, great. But don't wait until somebody wears a pro-life mask to work to change your dress code. If that's already in the dress code policy, fine. But if it isn't, you want to do it preemptively. You don't want it. You don't want the one person who's coming with one political message that maybe is not aligned with whomever, city administration. You don't want that person to be the one that triggers the change in your dress code policy. So that's about all I have to say this morning on masks, and I'll send it back to my friend Paul.
Thanks very much, Nuala. So now we're going to hand this over to Mia. She's going to talk to us about the continuing digital transformation process. And I do see that there's going to be some questions for Nuala. She'll pick those up after Mia's done. Thanks. Over to you, Mia.
Thanks, Paul. Good morning, everyone. So happy to have everyone here today. So I'm going to kind of talk about a little bit of a mishmash of topics this week. The first one being a continuation on the topic of digital transformation. Then I'll move to municipal funding, and then I'm going to talk a little bit about the new restriction for bars, restaurants, and food establishments that was announced this morning. So last webinar, I spoke about the significant uptake that we've seen in going digital since the COVID-19 pandemic began. From a technology perspective, we've seen a lot of challenges, but also a lot of benefits that have come from this. Municipalities always need to be considering how they're going to continue to move forward with implementing certain technology into the way that they're providing services. There's still a lot of opportunity for growth in this area, and I think it's going to be very interesting in what we see in the future about this and the different changes that we're going to see as we are in stage 3 and are eventually going to be fully reopened. Throughout our webinars, we've all touched on the importance of teamwork. So how does this affect digital transformation? Leaders of municipalities are learning from this experience, learning more and more about innovation and technology. Staff are full of great ideas. IT teams have great ideas and are always up to date with the changes in technology. And every department brings something different to the table when it comes to technology and how it works in those specific departments and how they're offering it through services that a municipality offers to its ratepayers. It's really important to recognize the different positive, I guess, how the different departments in a municipality are positively using technology, because then we can maximize how this is being offered as a whole for the municipality. Of course, there have been headaches along the way, but there's also been a strong commitment from everyone to drive this advancement with technology. When you have great leaders and great teams, you're creating the way for success in this regard. Municipalities, as we know, offer an array of services, and to keep these services running smoothly and adapting to changes that have come with COVID, all teams, as we've seen, have come together and continue to come together, and it shows. Everyone has been extremely focused. IT has been extremely focused, council has been focused, leadership, staff members, everybody's been very focused in moving in the same direction when it comes to technology. So that brings the question as to why sometimes are we hesitant or do we hold back from this digital transformation? Outside of this emergency that we've experienced with COVID, there wasn't necessarily a rush to advance with technology. With emergency situations, like we've said, you see the best and sometimes the worst when it comes to things. The digital transformation is scary, and for people, it's a bit of a mindset. It's not necessarily something you do, but it's something that you are. So you design your thinking and your services right from the get-go to be digital. We have to continue to be curious about this and research it and see what's available to municipalities and start thinking about how the digital experience will transfer into services permanently for a municipality, because 2020 is going to be very much digital and moving forward will be as well. So be patient, be innovative, and work together. So kind of connected to the digital transformation, kind of leads into municipal funding because the digital transformation, of course, is going to come at a cost. So I'm going to switch gears a little bit right now and discuss the latest development in municipal funding. On July 16th, the Prime Minister made a funding announcement that the federal government would provide $19 billion to the provinces and territories to help fund a safe start. The funding focused on 7 areas, with one being municipalities. Then most recently on July 27th, we saw the Ontario government, in partnership again with the federal government, is providing up to $4 billion in urgently needed one-time assistance to Ontario's 444 municipalities. This funding here will help the local governments maintain critical services that they offer every day, including public transit, over the next 6 to 8 months. Details on the specific allocations have not been provided yet, but are anticipated to be forthcoming in the next few weeks. So this funding is part of the province's Made in Ontario plan for renewal, growth, and recovery as we move forward with reopening. The government realizes under the circumstances that we're in that the failure to act could result in cuts to certain services that are offered by municipalities, and of course higher taxes. So this is something that of course we want to avoid. We want to avoid cuts in services, and we want to avoid higher taxes. So everyone is working together to press for funding to understand the needs that are specific to different communities, because every different community is going to have different needs. We know that transit systems have experienced losses given that revenues are at a low level, but now we're seeing a return as things start to open and people are starting to move around communities a bit more. So there's a bit of a uptake on revenues there. So right now we know that municipalities are considering what kinds of services will have to be cut, and what's being offered and what can continue to be offered, but the funding could change some of these decisions for the better. So that's a good thing. Other areas that are getting funding that will, in a tiny way, may affect municipalities as well, is long-term care, healthcare, mental health, and homelessness. This could impact municipalities and impact their delivery for promoting wellness within the community. So something to keep in the back of our heads as well. So this is good news. I think we have to stay tuned for the details as they're released. And of course, we will keep you updated as well. Lastly, as Tim mentioned, I would be touching on an announcement that came from the government this morning with respect to measures to further protect the health of Ontarians as the province continues to reopen under stage 3. The Ontario government, in consultation with the Associate Chief Medical Officer of Health, has amended 2 regulations. The first one being Ontario Regulation 364/20, which is rules for areas in stage 3, and Ontario Regulation 263/20, which is rules for areas in stage 2, under the Reopening of Ontario, a Flexible Response to COVID Act. So the government has now implemented additional measures for restaurants, bars, and other food or drink establishments. These additional measures are meant to help reduce close contact between individuals in these settings and support case and contact tracing, thereby limiting the spread of COVID-19. In order to keep patrons of restaurants, bars, and other food and drink establishments safe, the amended orders will implement the following measures. All patrons will be required to be seated at all times in both indoor and outdoor areas with limited exceptions. I'll circle back to the limited exceptions in a moment. Bars and restaurants in Ontario will also now be required to keep client logs for a period of 30 days and to disclose those client logs to Medical Officer of Health or an inspector under the Health Protection and Promotion Act on request. So this will support case and contact tracing. So last night I went to a patio, and as soon as I got there, they said, can we have a contact name and number for this party, and we'll include it in our contact tracing book. I've heard of other establishments that aren't doing that. Now it's mandatory. Every establishment has to do this. So with respect to exceptions to having to stay seated at all times is while you're entering the area or moving to your table, while you're placing or picking up a takeout order, while paying for your order, going or returning from the washroom, exiting the area, or while lining up to do anything that I just mentioned. So if there's a lineup for the washroom, you can stay standing while you're waiting in that lineup. And then of course, where it's necessary for the purposes of health and safety. So again, lots of different updates when it comes to, municipal funding, everything that Tim's mentioned. I think we're going to continue to see a lot of changes moving forward in the next few weeks. So of course, if you have any questions or need any clarification or assistance on how this can affect your municipality, please do not hesitate to reach out to us. Back to Paul.
Thanks, Mia. So we have some really good questions that we're going to get to now. So Vicky from Plumber Additional says, we've got no mask, no entry signs. And she asks, what about people who say they can't wear a mask due to medical reasons? And there's a concern that some people might use this to opt out without actually having a real reason other than they just don't want to wear a mask. So the answer to that is twofold. And the first is that if you are simply abiding by the order made by Algoma Public Health or other health units, I'm familiar with the one specifically from Algoma Public Health, and it says that you are not, as a business owner, supposed to ask people what the reason is that they're not wearing a mask, or rather, I guess, to be more precise, you're not supposed to ask them to document the reason that they're not wearing a mask. So the health unit is seeing this as a voluntary compliance process that they want to enforce with education and compassion, as Nuala would say. And I'm going to hand it over to Nuala to answer Lisa's similar question, because Lisa asks, what about employees that aren't cooperating with a mask policy? That's a different answer, and I'll hand it over to Nuala for that.
Yeah, that is a different answer. It's the same as any basically personal protective equipment that you'd require your staff to wear. So as employers, you have an obligation under the Occupational Health and Safety Act to keep the workplace safe and free from harassment of all kinds. But when we're looking at safety, we have an order from our local public health unit saying, wear the mask. We're doing it to keep staff safe. So if you have an employee not wearing a mask, the conversation goes rather like this. Sally, I noticed you're not wearing a mask. As the employer, I am required to keep the workplace safe, and part of that is requiring you to wear a mask. Please wear a mask. And then it's back to her to say, I have a disability, I have a respiratory problem, I've got an eczema problem, and she needs to put that forward. If she fails to put that forward, then it can be disciplinary. But if she says she's got a disability that prevents her from wearing a mask, then you have to look at reasonable accommodation, whatever that looks like. Maybe it's working remotely, maybe it's working in a different part of the building where she doesn't have access to the public, or any sort of creative and compassionate solutions that you can think of.
And that's the end of that, Nuala. So I will tell you as well that I've been dealing with an employer who has implemented a policy where they require their workers to answer a short questionnaire at the beginning of each shift to disclose whether or not they have been exposed to COVID, whether they've been following the guidelines and so on. There has been some serious pushback on that. I'm surprised about that in today's day and age, but there's been some serious pushback. And my advice is very similar to what Nuala just said. This falls right into an employer's obligation to take all reasonable steps to keep a healthy and safe workplace. And so the answering of a questionnaire about COVID is certainly not onerous. And it is really one of the ways that health units and industry standards have suggested that you protect your workplace, because we have an enemy that we can't see. And so my advice to the employer was that that questionnaire is just like a hard hat or a lockout procedure. It's a safety policy. It should be enforced initially with education and compassion, but also very strictly. And you ought not to permit people to come into your workplace if they're not following the questionnaire policy. Okay, so there's a question from Leah about contact tracing in municipalities and whether you should do contact tracing and whether retaining people's names is going to create an MFIPA issue. Certainly Nuala is our MFIPA expert, and I would like her thoughts on this, and I'm happy to discuss that with her. So Nuala, can you answer the question about whether municipalities should be doing contact tracing in the office and what MFIPA issues that creates?
Whether or not they should be doing the contact tracing, I think it's probably a best practice. It's probably going to vary from municipality to municipality how possible that is to do. But if you do adopt that, and I think we said this in an earlier webinar, but it falls right in the same category. So if you're having your staff fill in the questionnaire like we do at our firm every morning before we come to the office, if you're having your staff fill that in, or you're having members of the public fill in, those standardized questions. Have you traveled outside of the district? Are you experiencing any symptoms? Have you been in close contact with anyone that's tested positive for COVID? If you're asking those, and you create a record from it, or even like when you see restaurants collecting information for contact tracing, they're different because they're outside of the freedom of information legislation, but we're not as municipalities. If you are collecting that data, it is a record as defined under the Municipal Freedom of Information Protection and Privacy Act. All the rules that go along with records apply. That means the information can only be used for the purpose for which it was collected. It has to be stored in accordance with your record management bylaw. It can only be disseminated in accordance with the Act. So that means people would have to put in a request, pay the $5, have to be vetted through the legislation. And it is only destroyed in accordance with your bylaw and the Act. So I guess certainly you're not required to do contact tracing right now. If you want to implement it as a best practice, do so, but know that you're collecting information that will be personal in nature. It's actually medical information because you're, finding out how people are feeling physiologically. So it's going to be medical information, which is always considered personal. And it's going to trigger all the requirements of MFIPA. And last time I stopped talking, Paul seemed to think that that was abrupt. So I'll say back to you, Paul.
Much better, Nuala. Thank you for that.
Okay. You're welcome.
I have another question, and I'd like one of the team to put up their hand and answer this. So the question's from Michael, and he says, along the lines of food service outlets, no shirt, no shoes, no service. Could we add no mask, no service in a municipality and refuse service if there's not compliance? Sort of looking at Jan for this one, but I don't want to put people too much on the spot.
Yeah, just when you said refusing service, it obviously triggered me to go to the Human Rights Code and the duty to accommodate. So you still, if a member of the public has a medical disability, you still have to accommodate that as a service provider, not just as an employer, but as a service provider. But if it's just an outright refusal without any reason, that's a different situation. And you also,
I agree.
you're also, your Occupational Health and Safety Act, you're still protecting your workplace. That applies to members of the public who come in. So the same logic would apply.
So I agree with Jen on that. And we got to keep in mind that even though the Human Rights Code is triggered, that doesn't mean that you must allow people to put your folks in danger. And so if somebody, I think you can put a policy in place like that, Michael, to say no mask, no service. And then you might want to put a little asterisk on the bottom of the sign to say subject to human rights obligations, which can be discussed. And you can talk to the person who's requesting service about the disability and design some way to accommodate. So the accommodation might be to say, okay, well, you can't come into the office to ask staff this question, but you're welcome to send them an email or phone them, because then you're not face-to-face with them without a mask. That would be reasonable accommodation, in my opinion. So go ahead, Jen.
Would municipalities not already also have the procedures in place under the Accessibility for Ontarians with Disabilities Act? So you could just use that.
Indeed. And that is certainly something that municipalities are actively working on as the requirements of that act come into place. So, Michael, there's your answer. You can put a policy like that in place. It is subject to the duty to accommodate up to the point of undue hardship, and you can be creative in your accommodation process. So I'm going to end the poll and share the results of the poll with you now. So here we go. The issues: have you amended your procedural bylaw to allow electronic meetings? 67% have not yet. We have prepared a bylaw that we're happy to help you with. Please give us a call about that. Brittany has the contact information and process for that. It is critically important, if you're going to be having electronic meetings or having meetings continuing to be partly in the absence of the public, that you get that done at the beginning of your very next meeting. Interestingly, one municipality has amended the procedural bylaw to allow proxy voting. This doesn't seem to be an issue that has been super hot yet, but it is one that we're working on and we're happy to help with. And then, is your municipality still under emergency order? 5 of the folks online right now are still under emergency orders. That gives you some breathing room on amending your procedural bylaw, because the old amendments will still be in effect. So there you go. That is webinar number 15. Have a great long weekend. Certainly thanks very much to the team to help me out here. And thanks all of you for coming and attending yet again. We're going to be on 2 weeks from now to do this again and see what further changes to the legislation have happened. I'm sure that there's going to be a bunch more today, because various orders are expiring today. So we're going to see something from the province today. They usually wait until our webinar is over. I'm sure they watch it. And when we're done, then they change the law, which keeps us in business. So thanks to Doug for all that assistance. And thanks to all of you. Have a great long weekend.
And actually, everyone, just if anybody's interested, I just found out that the Health Canada is launching a contact tracing app today. So look for that on your cell phone if you're interested. That goes live today. So that's not a legislative update, but it's still kind of a neat thing that Health Canada is doing. So check that out. And
now for everybody online, we had forbidden Tim from talking about cybersecurity, and I'm not sure which side of the line he's on that. Anyway, have a great weekend. Take care.
Bye, everyone.
Bye, everyone.